All right, well, in the interest of time, I will go ahead and get started. So good morning or afternoon, everyone, depending on your location. Welcome to the Environmental Law Institute's annual Supreme Court Review and Preview event. Today is the first Monday of October, marking the first day of the Supreme Court's new term. We have some fantastic expert panelists with us today to offer an overview of key rulings and major takeaways from the court's last term, as well as to discuss the cases that have been granted review or are likely to be considered by the justices this term. I want to take a moment to thank our wonderful panelists for being here today and for their time preparing a great program for you. I also want to thank our audience for taking the time this afternoon or morning to tune in. We do encourage you to submit questions throughout the event. Please do not wait until the end to submit your questions, though. You can submit them as soon as you think of them by typing them into Zoom's questions box, which should be at the bottom of your screen. With that, I will go ahead and turn things over to our moderator, Jay Austin. Jay is a senior attorney at ELI, as well as the editor-in-chief of the Environmental Law Reporter. Thank you for moderating today, Jay, and I will hand things over to you.
Thank you, Madison, for the introduction. Good morning, everyone. Good afternoon. Welcome to our panel today. It is, as Madison said, first Monday. It's a historic day at the court, and environmental law is very much on the docket, literally so this morning and likely throughout the rest of this term. We have a lot to talk about today, and I will get right to it by introducing our two expert panelists, who are both veterans of this particular ELI panel, as well as leading scholars in the field. First, we have Sharon Jacobs, who's a professor of law at Berkeley Law School, where she teaches energy law, environmental law, and administrative law. And Robert Percival, who's the Robert F. Stanton Professor of Law at the University of Maryland Carey School of Law and director of the environmental law program there. Bob is also a former law clerk for Justice Byron White and has in fact just come from the court this morning, which marked Justice Ketanji Brown Jackson's first day on the bench, as well as the oral argument in Sackett versus EPA. We certainly plan to get to that case, but first want to start with a review portion of our program. So Sharon, please kick us off. Did the court decide any environmental cases last term?
Good question, Jay. Well, it's nice to be here with all of you this morning. And, starting with the review portion of this program, what the last term lacked in numerosity in terms of environmental cases, it certainly made up for in significance and impact in the West Virginia versus EPA case, which is what we're going to kick off with this morning, one of the most significant environmental law cases to come out of the Supreme Court in recent years. So this was, of course, a case about the Obama EPA's Clean Power Plan, which regulated greenhouse gas emissions from existing fossil fuel power plants under the Clean Air Act. And I'm going to start by saying it was very strange to many of us that the Supreme Court granted cert to begin with in this case, because the Clean Power Plan actually never went into effect. It was immediately challenged after it was issued, and the Supreme Court issued an emergency stay in the case. Later, the Trump administration repealed the Clean Power Plan and replaced it with the ACE rule, the Affordable Clean Energy Rule. And then the DC Circuit vacated and remanded the ACE rule. There's disagreement about whether that means the Clean Power Plan was technically reinstated or not, but at EPA's request, the DC Circuit stayed its vacator, if it existed, of EPA's repeal of the Clean Power Plan. Perhaps most importantly of all, the Biden administration consistently has expressed its intention not to re-implement the Clean Power Plan and instead to work on a replacement rule. So I say again, right, the Clean Power Plan, which never went into effect, was the subject of this case nevertheless. So, a plausible question here is, why was this case not moot? And the majority in the case says that the barrier to establishing mootness is extremely high and that they weren't going to rely on EPA's voluntary conduct in declining to reinstate the rule, right? The question was whether the allegedly wrongful behavior, right here, the rule, could not possibly expected to recur. And it said even if it dismissed the case as moot, EPA then was likely to promulgate a new rule relying on generation shifting, which is where the focus was in this case. So it took the case, ultimately decided that the Clean Power Plan was invalid. It was an improper reading of the Clean Air Act. So what was the case about? Well, Section 111 of the Clean Air Act requires EPA to set standards for emissions of certain pollutants from new and modified sources in a listed source category, and then subsequently for existing sources in that source category. They only regulate pollutants for existing sources that are not regulated under other major programs of the Clean Air Act, the NAAQS program, the Hazardous Air Pollutants program. And EPA has really only used this provision a handful of times, this 111D provision. It's used it to regulate acid mist from sulfuric acid production, sulfide gases from craft pulp mills, and some gases from landfills. The standards that EPA promulgates under 111D are to reflect what can be achieved using the, quote, best system of emissions reduction, which EPA determines has been adequately demonstrated, taking into account the costs of achieving those reductions, as well as non-air health and environmental impacts and energy requirements. And then the states implement that requirement by issuing rules to restrict emissions from sources within their borders. And importantly, the states don't have to adopt what EPA determines to be the best system of emissions reduction. They just have to achieve the reductions that EPA finds can be attained using the BSER. So EPA's Clean Power Plan regulated, as I said, greenhouse gas emissions from existing fossil-fueled power plants under 111D. And the BSER that EPA selected, the best system of emissions reduction, consisted of what it called 3 building blocks. First, it looked at what emissions reductions could be achieved at the site of individual plants using efficiency improvements. These are sometimes called heat rate improvements. Then second, it looked at what could be achieved, what emissions reductions could be achieved using a shift, or by allowing a shift from coal-fired power plants to natural gas generation. Natural gas plants produce about half the carbon emissions of coal plants, of course, in addition to reduced emissions of other conventional pollutants. So that was building block number 2. And the third building block was what emissions reductions could be achieved by shifting to more renewable generation. And EPA set emissions limits for each state based on what reductions in greenhouse gases it felt could be achieved by using each of those 3 building blocks. And so the question before the court was whether that approach to setting emissions limits under 111D was consistent with the statutory language. Specifically, could building blocks 2 and 3, which don't focus on what can be achieved at a single plant, but rather in the energy system as a whole, could those be part of a best system of emissions reduction? And in an opinion by Chief Justice Roberts, the court held that the Clean Power Plan was invalid, that those building blocks could not be part of a best system of emissions reduction. Really interesting that there was minimal engagement with the statutory text here, which we come to expect in a statutory interpretation case, right? Chief Justice Roberts did say that the word system cannot be read in isolation. He says you need to look at the words in context with a view to their place in the overall statutory scheme, but he really used this to pivot to what is called the major questions doctrine, which the court calls out by name for the first time. And so what the opinion did is identify a category of extraordinary cases where the majorness of the question should cause skepticism about Congress's intent to delegate the powers that the agency claims. And in cases like this, the Chief Justice said, courts need to look for a clearer delegation of authority. So what is this category of cases? Well, Chief Justice Roberts' approach to this is to tell us where the court has identified such major cases in the past. So he names the Brown and Williamson case about FDA's authority or lack of authority to regulate tobacco. He names the Alabama Association of Realtors case, which is the CDC eviction moratorium case. He names the UARD case about EPA's authority to regulate greenhouse gases in a different context, right? Gonzalez versus Oregon about drugs for assisted suicide, NFIB versus OSHA, the vaccine testing mandate, and really uses these cases to show that the Supreme Court has created a series of precedents defining this major questions doctrine, where agencies then must show that they have clear congressional authorization in extraordinary cases. Now, this is quite different from the Chevron type of Chevron deference that we've all become used to since the 1984 case. And the way I understand Chief Justice Roberts' articulation of the major question doctrine is we don't defer to agencies under Chevron, right? We take a step back and ask for a clear authorization for what the agency is doing, where we have an elephant in a mouse hole. I'm borrowing, of course, Justice Scalia's phrase here from Whitman. But there are two steps to that, right? The first is, do we have an elephant? So Chief Justice Roberts is saying, do we have a radical or fundamental change to a statutory scheme? Do we have the assertion of extravagant power over the national economy from UR? Do we have a transformative expansion in regulatory authority? So he's looking at factors like that to decide if this is an extraordinary enough case that the major questions doctrine applies. As part of this analysis, he also looks at how Congress has treated the issue. Is there post-enactment legislative history, which is a weird phrase that I don't really believe in, but how has Congress conspicuously and repeatedly declined, for example, to enact the regulatory program that the agency is claiming to have the authority to enact? So that's part of this, do we have an elephant? And then the second piece of this, which is very important to the Chief Justice and which I really want to emphasize, is, do we have a mouse hole, right? In other words, is the statutory provision that the agency is looking at to assert this authority, or in which it is grounding its authority, is it modest? Is it vague? Is it subtle, right? Does it have oblique or elliptical language? Is it an ancillary provision of this statute? And to see how this works in context, he then applies it to the Clean Power Plan. So first, do we have an elephant? He says EPA's assertion of authority in this case is really quite extraordinary. And he classifies it as deciding what the energy mix should be, how much coal-based generation there should be. He says this is unprecedented, that EPA's other efforts under 111D have focused much more modestly on what can be achieved at the sources themselves, and not in this sort of broader system, that they've confined system to a narrower sense. And he also notes that Congress has declined to adopt any kind of cap and trade scheme for carbon or a tax on carbon, and says that is essentially what EPA is pushing here, because one of the ways that states can comply with the EPA's BSER under 111D and the standards that they've set is by allowing plants to trade emissions credits. So do we have an elephant? The majority says yes. Do we have a mouse hole? Again, the majority says yes. He sets up 111D as an obscure, rarely used section of the law, later calls it a previously little used backwater, right? So a lot depends here on how we actually characterize the phrase itself in the statute that the agency is interpreting. And this is where I think, future lawsuits, or at least current lawsuits trying to invoke the major questions doctrine, maybe aren't focusing on this part so much, and they should be, because to the Chief Justice, at least, this is an important part of the major questions doctrine. So under the doctrines articulated by Chief Justice Roberts, the EPA's Clean Power Plan interpretation presents a major question, and therefore no deference to the agency's interpretation. And according to the court, this interpretation, EPA's interpretation, is not permissible. So the Clean Power Plan falls. Now, Justice Gorsuch's concurrence is very interesting in this case as well, because Justice Gorsuch clearly wants to put his stamp on the major questions doctrine, and his take is slightly different from the Chief Justice's take. So Justice Gorsuch has actually no engagement with the statutory text whatsoever, as Justice Kagan points out in dissent, and starts out by saying the major questions doctrine is just another clear statement rule designed to ensure that Congress keeps its statutes constitutional. This is actually quite an extraordinary statement, because here what he's suggesting is that certain types of delegation, or certain interpretations of delegation by agencies, would produce results that are in violation of Article 1's vesting clause. So he's sort of inching toward a revitalization of the non-delegation doctrine, that there are certain things that are just so big, Congress can't delegate them to agencies in the first place, certain types of discretion. But he really sees the major questions doctrine as one of these constitutionally grounded clear statement rules. It's clear Justice Gorsuch has no love for agencies in the administrative state, and that comes through loud and clear in this opinion. Lawmaking is meant to be done by elected, accounted officials, and if it's hard to pass laws and make change, there are good reasons for that, right? So here's his version of the major questions doctrine. He says, here's what you look for. You look to see if a matter is of great political significance. Okay, well, how do you decide if a matter is of great political significance? Well, you look to whether there are robust debates on a topic in Congress and state legislatures. You look to whether the agency is attempting to regulate a significant portion of the economy or requiring billions of dollars in spending by private persons or entities, whether they're trying to regulate vast swaths of American life. So this way of characterizing a major question would sweep in potentially many, many more agency regulations. Is there debate on? There's debate on everything these days, right? And you can even generate debate where none exist. Do regulations cost billions of dollars? A lot of really important regulations, especially in the environmental space, do come with hefty price tags. What he doesn't mention is that a lot of those regulations, of course, have corresponding benefits that outweigh the price tag or the dollars that they require industry to spend. So Justice Gorsuch's view of the major questions doctrine, which is being enthusiastically embraced by litigants already, is potentially much broader than the Chief's. And then also looks, of course, to the nature of the provision that's being interpreted. Just a word or two about Justice Kagan's dissent before we get to implications. So Justice Kagan in dissent pushes back vigorously on this idea of a major questions doctrine, which she finds prevents agencies from exercising their delegated authority and actually hamstrings Congress. She defends the administrative state a little bit against Justice Gorsuch's attack, explaining why Congress might want to delegate to agencies in the first place, right? Its lack of expertise, its absence of ability to follow a statutory scheme's implementation over time. And she says there's no reason for a major questions doctrine, that in the past cases the Chief Justice cites, the court was just doing ordinary statutory interpretation, relying on, this is a very Justice Kagan phrase, right, a modicum of common sense in applying existing doctrine. And the way she characterizes what's happening in those cases is that the court is telling agencies to stay in their lane, right? You think about the CDC moratorium case, for example, agencies should focus on areas where they're applying their traditional expertise. In the case of the Clean Power Plan, then, she said the agency did stay in its lane, right? This is business as usual for the EPA. It's regulating air emissions from stationary sources, including power plants. And this is what Congress expressly required and had in mind in Section 111D. This is not a big transformative action. As she points out, the Clean Power Plan would have had little to no impact, right? The plan never went into effect, and the goals were achieved anyway. And there are baked in limits right in Section 111D itself by virtue of the fact that the EPA has to consider costs, right? Has to consider energy requirements and other health and environmental impacts. And that there's no conflict with Congress's broader design here, that 111D was a really important gap filler, is a very important gap filler in a statute designed to rapidly reduce air pollution of all stripes, right? So what do we make of this case? I mean, it clearly is an important case. In terms of its practical impact on emissions from existing coal-fired power plants, I actually think the impact is quite minimal. The writing was already on the wall for coal-fired power plants. There are economic factors and state-level policies that are combining to drive coal-fired power plants out of business. And as I mentioned, power sector emissions, right, have already shifted, and we've already achieved the goals set by the Clean Power Plan, even though it never went into effect. Coal retirements are going to continue due to the economics and really actually quite interesting policies that states are enacting to help further the early retirement of coal-fired power plants. New Mexico and Colorado have bonds that they're issuing to support coal power plant retirements. And Wisconsin, which is Wisconsin's largest utility, is planning to drop coal from its power mix by 2035. So you have a variety of these state level politics that are going to be driving the shift away from coal-fired power production with or without the Clean Power Plan. EPA, of course, can still act under Section 111D, even after West Virginia versus EPA. The opinion did not specifically address this question of sort of inside the fence line, what can be achieved at a power plant versus outside the fence line, what can be achieved sort of more generally. It didn't directly address whether BSER had to be set based on what can be achieved inside the fence line, even if you read the case as saying we need to focus, EP needs to focus on what you can achieve in individual plants. EPA does still have some options. So one idea that's been floated is that EPA could designate carbon capture and sequestration as the BSER under 111D. This is especially true given the new funding that's now available for carbon capture in the Inflation Reduction Act. That was, of course, the BSER that they selected for new power plants initially. And that could enable them to set really stringent emissions limitations for those plants. What else could it do? EPA is considering a wide variety of approaches to regulating carbon emissions from the power sector under the Clean Air Act. Right now, they're going out for lots of stakeholder engagement, lots of public meetings, really in an information gathering stage, but they could increase the stringency of traditional pollutant regulations. They could amp up requirements under the Good Neighbor provision of the Clean Air Act. There's a lot that EPA could do that would either directly or indirectly affect the amount of carbon that's coming out of our power plants, notwithstanding this particular opinion. And I think one additional thing that's worth mentioning is that the court chose not to engage at all with what I think is the vastly overblown debate about the House and Senate versions of the 111D amendments, where, you know, Judge Walker in the DC Circuit was very excited about this argument in his dissent, and he's talking about 111D. Of course, there were differing versions that came out of the House and Senate when this provision was passed. The conference committee selected one of them. But if you actually look at the text in one of the versions, it is possible that version suggests that EPA cannot regulate any source categories under 111D that are regulated under the hazardous air pollutants program. And that would preclude the regulation of power plants here, which are in fact regulated. Some of their hazardous air pollutants are regulated. But the better way to read that provision, I think what the Chief Justice and the court concluded, the better way to read that provision is that under 111D, you cannot regulate pollutants from source categories that are already regulated under the NAAQS and under the hazardous air pollutants section. So the fact that that argument didn't even make it into the opinion, I think, suggests that the court's not skeptical about EPA's authority to regulate emissions from power plants under 111D, full stop. And before I stop, I just want to say the big implications of this case for environmental and energy law going forward are going to be from the major questions doctrine, right? So despite, I think, the Chief's best efforts of elaborating the doctrine through case law in the opinion, it still remains very much an I know it when I see it doctrine that's going to need a lot of careful discussion in the lower courts, right? So there's the does it cause the judge to raise an eyebrow framing? I mean, this could mean different things to different judges. When do they raise their eyebrow about the nature of a question before an agency? And we already have several suits that are percolating up in the energy domain. There are a couple that I hope we have time to talk about a bit later. And certainly there are risks in the environmental context as well. So I will stop there for now, but I hope we have a chance to talk a little bit about major questions and its implications later on.
Okay, the other environmental case the court decided last term was actually decided as one of the first decisions of the term. It's the case of Mississippi versus Tennessee. As you know, Article 3 of the Constitution gives the Supreme Court original jurisdiction over lawsuits between states. And in this case, the state of Mississippi claimed that Tennessee was stealing its groundwater, the Middle Claiborne Aquifer, which underlies 8 states and has some of the best, purest groundwater around. It's been there for thousands of years. The city of Memphis, which is just across the Mississippi border in Tennessee, had been pumping 120 million gallons of this groundwater each day. And Mississippi argued that because the groundwater that was beneath Mississippi was due to a cone of depression caused from this pumping moving across the border into Tennessee, that Tennessee was essentially stealing all this groundwater. And they sought $615 million in damages by arguing that this pumping was drawing groundwater that had been beneath Mississippi across the state line into Tennessee. Now, what was significant about this case is it shows that the interstate disputes over water issues, which the court has always heard in its original jurisdiction, that are becoming more significant these days as water demand seems to be exceeding supply in some places, now extend not just to surface waters, but also to groundwater. This was the first case the court dealt with that dealt with groundwater. And the way in which the court has usually dealt with the cases involving disputes over surface water is through equitable apportionment, figuring out that when waters cross state boundaries, what is the right of one state to share the amount of water with another state and how that's to be apportioned between them. Here, the state of Mississippi did not ask for equitable apportionment. The court appointed a special master, but Mississippi said, no, what you should do is just figure out how much of our groundwater is being stolen. Mississippi had to concede that the natural flow of the aquifer slowly was moving from Mississippi towards Tennessee. So not all of it was happening as a result of the cone of depression created by all this pumping of groundwater. The special master actually recommended that because Mississippi was eschewing equitable apportionment, their complaint should be dismissed, but he said that the court should grant leave to amend the complaint to request equitable apportionment. And on November 22nd of 2021, the court, in a unanimous decision authored by Chief Justice Roberts, agreed that equitable apportionment of water rights applies not only to surface waters, but also to groundwater. And so the court acknowledged it was making new law in applying this doctrine to interstate aquifers. But since Mississippi did not seek equitable apportionment, the court dismissed Mississippi's complaint as recommended by the special master. Since Mississippi had not even asked for equitable apportionment, it did not specify that leave should be granted to amend the complaint. That's really the only avenue open to Mississippi now. So I think, we'll continue to see these water disputes. There's another one this year where the Interior Department's asked for cert involving water rights for the Navajo Nation that we may have time to talk about a little later. And the court usually defers to the special master in these cases, although a couple of years ago in the dispute between Florida and Georgia, the court overruled the special master, appointed a new one, and then later unanimously essentially agreed with the original special master that no relief could be granted to the state of Florida for Georgia's uses of water that were affecting the amount of water flowing into Georgia. So that was pretty much it for the cases decided last term. Now this term, the big case was argued this morning, Sackett versus EPA. And this has a long and complicated history. The court just last week, after it had its long conference on Wednesday, for the first time announced that the court was going to be open to the public in that members of the bar, limited members of the public would be allowed in to watch the oral argument. It was the first day that the newest Justice, Ketanji Brown Jackson, would be sitting on the bench. So since I live a short distance away from the court and I'm a member of the Supreme Court Bar, I confidently strolled over there about 7 o'clock in the morning and was shocked that the building was still closed. And the guards were saying, if you're a member of the Supreme Court Bar, instead of lining up in the nice, comfortable basement of the court in the bar line was going to be out on the street, on the sidewalk, when it was drizzling, and it was actually 48 degrees when I left my home. So the bar line formed out on the sidewalk. I had not brought a coat or an umbrella. Fortunately, the drizzle let up. And then the guards announced, after waiting for about a half hour there, that the court had decreed that only 19 members of the bar were going to be let in. And the guards started counting how many people were in line. And when they got to me, they pointed at me and said, "You're number 19, so you get in." The others, they essentially told, "You might as well go home. You're not getting into the court." There was a lawyer from Earth Justice, someone from the Waterkeeper Alliance behind me in the line. And they did then at least let me into the courtroom where we stood in line. And instead of starting to process the bar members they used to start that usually about 8 or 8:30. They waited and waited until it was about 9 o'clock, and then they started processing that. And when it got to number 16 in the line, they announced we're all out of passes. Mysteriously, 3 of the passes had either gone to people cutting in line. I don't know how they got in the building. They had no explanation, but they said, "You're not getting into the courtroom." And so that left me with a real dilemma. We said, can we listen to the argument in the lawyer's lounge, which was usually the convention? If you didn't get a seat in the actual courtroom as a bar member, you were always guaranteed you could at least listen to the argument in the lawyer's lounge. They said, "I don't think we're doing that this year." So they said, "Well, we'll see what we can do for you." But it got to the point where I was going to miss even being able to hear the oral argument if I didn't scurry home. So I got home and made it in time for the oral argument at 10 o'clock. Now, one thing to know about the oral arguments this year is that they're not adhering to the strict time limits that they used to. You could, in the past, set your watch by the 1 hour allotted for oral argument. But like many other courts, like the DC Circuit, time limits no longer are really honored that much. The justices genuinely want to hear what people are saying. And in the court during the pandemic, what happened was the justices would take turns in order of seniority asking questions. Now they allow counsel to have 2.5 minutes at the start uninterrupted. Then they ask questions, and then at the end, they go around to each justice in order of seniority to see if they have any other questions. So a 1 hour argument actually just ended just before we went on the air with this webinar. So it took almost 2 hours. Now, the dispute might sound familiar with you. It's over the reach of the Clean Water Act. The Clean Water Act regulates navigable waters, which the act defines as waters of the United States. And in the Riverside Bayview decision in 1985, the Supreme Court, in a unanimous decision authored by my old boss, Justice White, said when there's a wetland adjacent to a navigable water, we'll defer to the Corps' regulations if they think that it should require a Section 404 permit before dredged and fill material can be placed in the wetland. Later in 2001, in the Swank decision, the court limited the Corps' authority by saying that a wetland that was completely isolated and far away from navigable waters, where the only basis for federal jurisdiction was that migratory birds used it, was not something that could be regulated under the Clean Water Act because Congress did not intend that. But then the blockbuster ruling that caused massive confusion to this day was the Rapanos case. That was decided in June of 2006. The first term that Chief Justice Roberts, who at his confirmation hearings had vowed that he wanted to bring the court together and not have such fractured decisions. This case involved a wetland in Idaho owned by the Sacketts. Sorry. Rapanos was a wetland in a non-navigable tributary of a navigable water that was a wetland area. Rapanos wanted to build a huge subdivision. He consulted with his consultant who said, "You clearly are going to need a Section 404 permit." He said, "EPA be damned," got out his own bulldozer and started filling it, and was then given a cease and desist order by the Corps. And the question there was, can a non-navigable tributary of a navigable water, a wetland adjacent to a non-navigable tributary of a navigable water, be regulated under Section 404 of the Clean Water Act that uses the same language as the Section 402 NPDES discharge permit program? And the problem there is the court split 4-1-4. A plurality opinion authored by Justice Scalia adopted what many consider a radical narrowing of the Clean Water Act to say that only wetlands that had continuous surface connections with navigable waters could be regulated. 4 justices said, let's defer to the court, their regulations are fine, and this can be regulated. And then Justice Kennedy, who apparently was incredibly stubborn, at least that's the story I get from the law clerks who were there at the time, came up with his own significant nexus test. He said that if the property had a significant nexus to navigable waters, so that dumping dredged or filled material in it could affect the chemical and biological and physical integrity of navigable waters, that this substantial nexus would be enough to give the federal government jurisdiction. Now, all 8 other justices rejected Justice Kennedy's test, but it effectively became the necessary deciding vote you had to get. So that in a concurring opinion, Roberts, embarrassed by the fact that the court was so fractured, said the real problem here is that the court should revise its regulations. If they adopted regulations to be clear about what wetlands were regulated and what weren't, we would probably defer to them. We might even grant them Chevron deference. That was at a time before Chevron became a dirty word in the Supreme Court. So then 6 years later, the court decides the initial Sackett case. That was a case with the wetland in Idaho that the Sacketts wanted to fill. It's right in close proximity to Priest Lake, which is a very large lake, very pristine. And it's separated from the lake by a small row of houses that are right on the lake. And then in the other direction by a highway, which separates it from what clearly is a substantial wetland that drains into an unnamed tributary that goes into Priest Lake. And when the Sacketts also hired a consultant and were told you have to get a Section 404 permit, they said, no, we're going to just start filling it. They started filling it. And then they got an EPA unilateral administrative cease and desist order saying, stop filling this, you're violating the Clean Water Act. Now, under the law at the time, they had no legal remedy because they weren't allowed to challenge in court unilateral administrative orders like that. All they could do was to violate the order and then challenge any EPA enforcement action brought against that. They then appealed and it went all the way to the Supreme Court, and a decision in 2012, the court said that you can seek judicial review of unilateral administrative orders. In a subsequent decision called the Hawks decision, the Supreme Court said that property owners also, if they don't like jurisdictional determinations that they can get for free from the Corps, if you ask, do we need a permit, they also can challenge those and get judicial review of that in court. Now, a decade later, after the initial Sackett decision, once again, they want to fill the wetland. And the question is whether or not it's covered by as waters of the United States. And the lower courts, applying the substantial nexus test from Justice Kennedy in the Rapanos case, had no problem finding that this property was a regulated wetland, that developing the property would have an impact on the quality of the water in navigable waters of the United States, Priest Lake. And they appealed it to the Ninth Circuit, and the Ninth Circuit, again applying the substantial nexus test, said yes, they have to get a permit. Now, it's rather surprising that the court took this case, and I think the reason is because they thought the Sacketts were particularly sympathetic plaintiffs, since they've been wanting to develop this property since at least 2008. And what it ignores is the fact that the Obama administration had indeed responded to Chief Justice Roberts' suggestion in the Rapanos case and adopted a new definition of waters of the United States. Now, that was quickly repealed by the Trump administration, which adopted its own navigable waters protection rule, which was very much like Justice Scalia's plurality opinion in Sackett. It rejected any kind of substantial nexus test, which had been the linchpin of the Obama administration WOTUS rule. Now, to show you how much litigation and confusion this is demonstrated, the Supreme Court in 2018 actually had to decide whether challenges to the Obama WOTUS rule could first be brought in the district courts or in the courts of appeal, because while it's clear that you can challenge rules under the Clean Air Act in the courts of appeal, this was really not a new rule. It was just a clarifying statement of the existing law. And in fact, the court held that those should first be brought in the district courts. So there's been lots of litigation percolating with respect to not only the Obama rule, but the Trump administration's navigable waters protection rule, which has been struck down by a district court and has been stayed. And in the meantime, the Biden administration says, we're going to adopt our own rule, we'll repeal the navigable waters protection rule and adopt our rule. So when this case came before the Supreme Court on cert, it was clear that the plaintiffs, represented by the Pacific Legal Foundation, wanted to get the court to adopt a very narrow test that would say that only wetlands that directly abut navigable, in fact, waters or things that are waters of the United States can be regulated under Section 404. And in light of the new conservative bent of the Supreme Court, I think there's a lot of hope that the court will do that. Now, as far as the argument went, I did listen to all the argument and a few observations. Of course, it's always hazardous to make predictions, but I think the Solicitor General defending the current administration interpretation of the Clean Water Act did quite well. One thing that became apparent early on is that the newest justice, Justice Jackson, has really done her homework. She asked some great questions and honed in right away, as did Justice Kagan, on what became sort of the focus of the oral argument was Section 404G, which is a provision added to the Clean Water Act in the 1977 amendments that authorizes states to apply for delegated authority to operate their own permitting programs. What's so significant about that is that the court had just months earlier adopted the broader regulations to regulate wetlands adjacent to navigable waters, and the statute expressly used the term including adjacent wetlands. And so part of the argument was, why didn't they use abutting instead of adjacent if Sackett is right that it has to actually touch it? Amy Coney Barrett, Justice Barrett, said to the counsel for the Sacketts, 404G is the biggest problem for you. The tenor of the argument was, you could see the three supposedly liberal justices, Kagan, Sotomayor, and Justice Jackson, are strongly on the side of the government. The three most conservative justices, Justice Thomas, Justice Alito, and Justice Gorsuch, are firmly on the side of the Sacketts. But there's hope for the middle justices, Chief Justice Roberts, Justice Kavanaugh, and Justice Barrett. And I think one of the things that Kavanaugh showed he had really done his homework is that he pointed out that even under the navigable waters protection rule that the Trump administration had issued, that having that highway separating your property from what clearly was a jurisdictional wetland would not have been enough, because artificial structures or berms, even under the navigable waters protection rule, would not be enough to make it a non-jurisdictional wetland. And Kavanaugh also pointed out that this has been the position of 7 straight administrations. And now what you're trying to do is say, just rewrite the Clean Water Act by coming up with your new argument about what the extent of jurisdiction should be. Now, I actually think that some members of the court are looking for some kind of compromise. At one point, Kavanaugh said, well, is there a way that we, without doing much damage to the current regulations, can let the Sacketts win? And Solicitor General said, no, this is so clearly a jurisdictional wetland. Justice Sotomayor at one point asked, is there any way to provide more clarity? Because Justices Thomas, Alito, and particularly Gorsuch kept saying, how's the ordinary homeowner going to know if their property is regulated? And the response was, ask the court for a jurisdictional determination and they'll tell you. But of course, that wasn't good enough for them. And in response to Sotomayor's question about, is there any way to provide more clarity? The Brian Fletcher, representing the Solicitor General, said, well, we have a rule over at OMB right now that's going to be out in proposed form by the end of the year. It's going to be the Biden administration's interpretation, and it will probably be more limited than the old waters of the United States rule that the Obama administration promulgated, though somewhat broader than the rule that the Trump administration had issued. Finally, Justice Alito, towards the end of the argument, tried to sort of bring in major questions and West Virginia versus EPA by saying, look, isn't there just underlying all this a clear statement rule, which is what major questions is now being described as, that just by having that phrase adjacent wetlands in 404G, that's trying to read too much in it. Congress should have, in fact, been a lot clearer about this, and maybe on that grounds, we can adopt a completely different construction. I see this case as really just an invitation to the court to engage in rewriting the Clean Water Act. I hope they don't do that, and I think there's some hope given the possibility that Justices Kavanaugh, Barrett, and potentially Chief Justice Roberts could join the 3 liberals in an opinion that doesn't do a lot of damage to the Clean Water Act. Now, another case that the court has agreed to hear is going to be argued on October 11th. I would not recommend trying to get in to see the argument in light of my experience this morning, but Sharon's going to cover that.
Yeah, sure. Thank you, Bob. So I am just going to say a few words about this case. It's going to be argued on October 11th, the National Pork Producers Council versus Ross, because this is a case that is not squarely within the domain of environmental law, although it does involve animal welfare, but it's a case involving the so-called Dormant Commerce Clause. And so the ruling in this case could have implications for environmental matters, especially for state efforts to enact renewable electricity standards, renewable energy standards, renewable fuel standards. And I want to highly recommend my colleague Dan Farber's Legal Planet post on this case, which I think is really useful. And I'll just give a very quick overview of it here. So this is a case about California Proposition 12, which was an initiative, a voter initiative adopted with 63% support in 2018, which says there should be no sale of pork in the state if the sows that are either the source of that pork or that produce the piglets that became that pork do not have enough space to lie down, stand up, fully extend their limbs, or turn around freely, requiring us 24 square feet of floor space. So this is pushing back on this idea of really small confining gestation crates for sows in the pork industry. The purpose behind the initiative, of course, was to prevent animal cruelty, but also stated purpose was to protect the health and safety of California consumers by limiting foodborne illness and their related fiscal impacts. The challenge is that almost all of the pork sold in California comes from out of state. And another challenge is that almost none of the industry currently meets this requirement. And so this would actually require significant changes in the industry at costs that would raise costs about 9%. And another challenge here is that the way the pork industry works, it's really impossible to tell where the pork that producers sell is going to end up in the country. So they have to assume that some of it will end up in California, and therefore the argument is this is going to require major and expensive changes on the part of the pork industry. So the legal challenge is that this proposition, which is now law in California, violates the so-called dormant commerce clause, which is the inverse of the traditional commerce clause, which gives the federal Congress power to regulate commerce among the several states. The dormant commerce clause is a doctrine that says there's implicit preemption of state laws that discriminate against interstate commerce or impose an undue burden on interstate commerce. And the court has approached this doctrine in different ways. First, it's stated that facially discriminatory laws are per se invalid. So this is clearly not a law that facially discriminates against out-of-state producers in favor of in-state producers. But the argument here is that it violates another prong of the Dormant Commerce Clause, which is the prohibition on extraterritorial regulation, that states may not regulate actors wholly without the state, so outside their borders, that's per se impermissible. And there's also a challenge under the third prong of the Dormant Commerce Clause, or which I think of as the third prong, which is the Pike balancing test. So the court has looked at cases and asked if a state law has burdened interstate commerce in a way that clearly outweighs the legitimate local benefits of the law. So the allegation here is that this places significant burdens on out-of-state producers, and that the local benefits or the putative local benefits are either minimal or non-existent. So the Ninth Circuit found there was no extraterritorial regulation here because the law is confined to sales that take place during the state, and this only bans one profitable method of operation and doesn't ban pork production more generally, and that doesn't qualify, therefore, as extraterritorial regulation. Also, that these alleged cost increases to companies that they'll pass on to consumers don't qualify as a substantial burden for purposes of Pike balancing, that an increase in cost is not enough to satisfy that standard. So the Ninth Circuit upheld Prop 12. Interestingly, the Solicitor General has weighed in on this, has filed a brief agreeing with the pork producers that Prop 12 is invalid under Pike balancing since it doesn't further a legitimate state interest. And the argument here is that really what's motivating this law is some kind of ethical or moral ideal about how pigs should be treated, that there's no actual impact on the prevalence of foodborne illness, that this new method would not actually protect consumers in California. So there is no legitimate local interest here, and therefore, right, any kind of burden would outweigh that. The Solicitor General does not think the court needs to reach the extraterritoriality prong, although it does think the Ninth Circuit erred somewhat in describing Supreme Court precedents. The Ninth Circuit said the Supreme Court has really limited the extraterritoriality cases to pricing cases. And the Solicitor General says that's not really so. You can assert a successful extraterritoriality claim that's not about pricing if there's no legitimate local interest. So really focusing on this legitimate local interest piece. So what should we watch for in this case? So we know that Justice Thomas is, to put it mildly, highly skeptical of the Dormant Commerce Clause. And there may be other voices on the court out there that are as well. Will the Supreme Court offer more clarity On extraterritoriality, this is a somewhat ill-defined doctrine. Should it be a standalone doctrine? Should it be just one element within the Pike balancing test? How exactly do we define it? Maybe the court's going to take the opportunity to provide some clarity there. Will it take the opportunity to change or even reject the Pike balancing test? And the court has backed away from balancing in recent cases. It cited a lack of judicial competence to engage in this kind of, what is the economic burden outside the state? What is the benefit inside the state? This is sort of what outside the domain of judicial competence. The implications for environmental cases here, if there is, if the Supreme Court takes this opportunity to reinvigorate extraterritoriality, that could be a problem for state climate policies. So California, in a case in 2019, the Ninth Circuit upheld California's low carbon fuel standards. It's a case called Rocky Mountain Farmers Union, relying on a logic similar to that it deployed in the pork producers case. It said there's no extraterritorial regulation, even though the low carbon fuel standards effects fell primarily on out-of-state entities, unless the Ninth Circuit said the state is directly regulating conduct that's wholly out of state. If we see a different view from the Supreme Court and a willingness to expand its understanding of what extraterritoriality is, that could threaten not just Proposition 12, it could threaten the low carbon fuel standard and related standards that do impose significant effects on out-of-state producers, even if what's being technically regulated is the sale of a product in state. We also have renewable energy standards that have been upheld by, say, the 10th Circuit in the Appel case, upheld Colorado's renewable energy standard from a challenge by fossil fuel generators. And again, holding that simple de facto extraterritorial effects, the fact that this was going to have an impact on out-of-state coal power plants did not invalidate the statute. So something to look for there. A renewed emphasis on Pike balancing, which doesn't seem terribly likely, that could be problematic as well if the court wants to redefine or make it harder to establish a legitimate local interest, if it adopts some of the reasoning in the Solicitor General's brief, for example, and really starts testing what a legitimate local interest is. I suppose there's some risk that it would be harder for a state to establish lowering carbon emissions, which are, of course, carbon pollution is well mixed in the global atmosphere, as a legitimate state local interest, right? How local is that interest? I don't see a huge risk there right now, but it's a possibility. I personally want to align myself with what David Driesen has said, that states have to regulate extraterritorially to some extent to realize regulatory goals because our world is so integrated. So we'll be keeping an eye on that case, but it is worth flagging as the argument approaches on October 11th. And now I think we are going to turn to a few cert petitions that we are watching. So back over to you, Bob.
Yeah, I just want to mention one other case that's going to be argued 4 weeks from today. It's consolidated cases, Students for Fair Admission versus University of North Carolina and versus Harvard. And those are the cases where there are challenges being made to the admissions policies that take into account race. And the allegation is that there's discrimination against Asian students. And the plaintiffs in that case are actually asking the Supreme Court to overrule its 2003 Grutter decision, where the court had held that there's a compelling interest in the educational benefits of having a diverse student body. Now, how does this imply environmentally? If the court, as some people think it might do, simply says you cannot consider race for anything, even for remedying historical racial disparities, the issue would then be, are some of the environmental justice initiatives that EPA is developing that take into account the percentage minority of communities that have been sacrifice zones, would they be vulnerable? I'm only just saying we should all be aware of this. I know EPA is aware of this, and we'll see what the court does there. Now, cert petitions, the one that I want to talk about is one that the court to date didn't grant or deny, but it asked for the views of the Solicitor General on. And that's this Suncor versus Boulder case. Now, you may remember that 2 years ago, actually a year and a half ago, in May of 2021, the court decided the BP versus Marion City Council of Baltimore case that involved a technical question on which the court perceived a tiny circuit split involving the reviewability of removal orders. Many, many cities, counties, and states have sued the fossil fuel industry based on state common law tort claims. We know that in 2011, the Supreme Court unanimously in the American Electric Power case said that the Clean Air Act displaces the federal common law of nuisance for climate-related injuries, but it expressly took no position about its impact on state common law. Now, many of these governments are arguing that the fossil fuel industry deliberately deceived consumers by denying climate change, funding groups to promote climate change denial, and they're now suffering injuries from the impacts of climate change. And so they're using, like garden variety tort claims, state fraud statutes. And this is going on all over the country. In every single one of these cases, the oil industry has removed them to federal court. And they would like to make the argument that since the federal common law of nuisance is displaced, that the state common law of nuisance should also be preempted. When they succeeded in getting the Supreme Court to take the BP versus Marion City Council of Baltimore case, the issue on which cert was granted was whether or not you could review other grounds than federal officer or civil rights removal. And the Supreme Court said you should be able to review all grounds for removal. Now, what's happened is in every single one of these cases, the federal courts have said they belong in state courts. They're garden variety state law tort claims. The Supreme Court generally has stayed out of monkeying with state tort law. And but what the fossil fuel companies are arguing, and they did this in the Baltimore case, once they got to the Supreme Court, they said, well, this case was granted on the narrow grounds about what grounds you can review removal orders, remand orders in removal cases. Now that we've got your attention, why don't you just hold that because climate change is a global issue, all of these cases must be governed by federal common law, and therefore it's all displaced because the Clean Air Act, you said in American Electric Power, displaces federal common law. They're trying to make it look like there's some circuit split because there is one New York case where a court said something similar, the Second Circuit panel did, but that was in a case that was filed initially in federal court, explicitly asserting the federal common law. So the notion that states can't use state common law in what ultimately might be something like the global settlement we saw in the tobacco litigation years ago, where if these companies are held liable under state common law, they'll have to pony up lots of money for climate change adaptation and the like. Now today, what this time the cert petition came from a 10th Circuit decision that in fact the district court's order remanding the litigation back to state court was proper. They're making the argument once again that the court should take it to wipe out climate litigation using the federal common law. It's kind of transparent what they're trying to do. They just want this litigation wiped out. Now, if you remember the Juliana case, when that went up on interlocutory appeals, at one point, both Justices Gorsuch and Thomas said they would just order it completely dismissed, showing a hostility to climate litigation. So I suspect there are some of the three more conservative justices that would be sympathetic to this. When this was at oral argument in the BP case 2 years ago, Amy Coney Barrett said that would be awfully aggressive of us to rule that it's all governed by federal common law and therefore has to be wiped out. It's also kind of ironic given that in American Electric Power, the gist of the court's decision was that EPA was the expert in deciding whether, when, and how to regulate greenhouse gas emissions. So we should not allow common law nuisance liability. And yet in West Virginia versus EPA, they're saying, oh, EPA doesn't have the authority to do it the way it wants to do it. Let's see. You want to do the FERC eminent domain case?
Yeah, let me just spend 1 or 2 minutes talking about this case, which I don't know that it has a good chance of being granted, but there is a cert petition in a case called Bohan versus FERC, which is notable because it's about the Mountain Valley Pipeline, which is a pipeline taking gas from West Virginia out to points east. And it is a favored project of Senator Joe Manchin. In fact, it's the project for which he attempted to extract concessions in signing on to the Inflation Reduction Act. Didn't end up requiring concessions on this particular pipeline as a condition of his support, but it's clearly a project he cares a lot about, and we're expecting to see something more about it in future legislation. The nature of the question presented here is rather narrow. So it's the case is attacking FERC's eminent domain power to take private lands to site this pipeline. And so these are plaintiffs who refused to sell their land to the pipeline company. The pipeline invoked eminent domain and filed condemnation actions. And the plaintiffs challenged the delegation by FERC of eminent domain authority to the private pipeline company in district court, but the district court dismissed for lack of jurisdiction. So the question presented here is, does a facial challenge to congressional delegation of eminent domain power to essentially hear private parties through FERC, is that properly filed in the district court or with FERC in the first instance as a kind of collateral, a challenge to FERC's approval of the pipeline order itself? I mean, if you actually get to the underlying merits of the plaintiff's claim, the case seems pretty straightforward because the Supreme Court in a recent case called Penn East clearly decided that delegations of eminent domain authority to private entities in the public utility context are constitutionally permissible in general. That case was specifically about delegation of authority, eminent domain authority to take state lands, but the reasoning certainly applies more generally. The court said in that case, since the founding, the federal government has exercised its eminent domain authority through both its own officers and private delegates. So this case will really, whether or not the court takes it is going to turn on whether it thinks it's important to clarify the forum in which such cases should be brought. And again, it does touch on a key political issue of the moment, which is the future of energy infrastructure siting generally.
Well, thank you both. Relatively small number of cases, as Sharon said, but all potentially very impactful, a lot of ground covered. As I've been telling law students, if you take the West Virginia case alone in its entirety, a majority concurrence and dissent, and you read through it and follow all the arguments, follow through all the citations, that's essentially your syllabus for the current state of environmental law, at least at the Supreme Court, and much of regulatory law besides. I do want to get to audience questions. Predictably, they are more or less clustered around the West Virginia case and the Sackett case. So I'm sort of inclined, for starters, to maybe just take one from each column, one for each of you, at least in the first instance. Both welcome to chime in, and then we'll see where that gets us and what that leads to. So on West Virginia, Sharon, implications, a lot of questions, obviously, about sort of lateral, adjacent, if you will, impacts on related agency, non-EPA efforts to rein in climate change. And the specific question today, in view of West Virginia, does the panel feel that the SEC's proposed climate risk disclosure rules would survive a legal challenge? Because the proposed rules, opponents claim, do not have clear authorization from Congress. I don't know which of you purports to be a securities and exchange expert, but feel free.
So I'm not a securities expert, but I'm happy to take that question. I mean, so I think this is a good example of the type of case in which we're going to see challenges under the major question doctrine after West Virginia versus EPA. I mean, we've already seen the major question doctrine deployed, and the Republican state AGs have challenged FERC's proposal, the Federal Energy Regulatory Commission's proposal on long distance transmission planning in organized wholesale markets as overreach under the Federal Power Act, with their argument being that FERC has no authority under that statute to affect the power mix, the generation mix. We've seen an argument in the Fifth Circuit where Texas is arguing the Nuclear Regulatory Commission lacks authority under the Atomic Energy Act to license private facilities to store radioactive waste. As we know, this is a huge problem, the long-term or even medium-term storage of highly radioactive waste. So, you know, I personally predict that both of those cases are going to fail, and I'm happy to talk about why. But the SEC climate risk rule, I also think this challenge will fail, but it might be a closer call, and it depends on the scope of the final rule, which we haven't actually seen yet. But here, right, the SEC is likely going to require the disclosure of greenhouse gas emissions and serious climate risks from publicly traded companies to investors. And, you know, this kind of risk disclosure is the SEC's bread and butter, right? This is what they do. So this is not like a case, you know, from the majority's perspective, not from my perspective, this is not like a case like the Clean Power Plan where the majority thought EPA was reaching out to regulate the energy sector, seeing EPA as more of a regulator of emissions. This is a case of the SEC doing exactly what it's always done, which is to require the disclosure of material risk to investors. And climate is certainly a material risk to investors. It's very hard to argue with that these days, especially when countries around the world are requiring just this type of disclosure. So if you think about the major questions doctrine as an agency staying within its lane, I think the SEC is clearly staying in its lane here, although of course, in the final analysis, this case, like any other case, should turn on the statutory fit, right? Looking at exactly what the SEC requires and whether that fits within the agency's statutory mandate.
Bob, anything to add on the sort of current scramble to find elephants in mouse holes? You're muted, Bob.
It's like the old adage, if you're a hammer, everything looks like a nail to you. In Washington now, everything's major questions. In fact, the DC Bar has an ethics complaint about Jeff Clark, the guy that Trump wanted to appoint as Attorney General. And in his defense, he's raising major questions, which is just amazing. So you'll see it raised all the time. And Alito was trying to go there today at the second oral argument. I don't think the others were.
I wanted to ask just a specific application of that another sort of whole of government, all hands on deck approach highly touted by the Biden administration has been its efforts to advance environmental justice and executive orders directing a number of agencies to take actions. Do either of you see ways in which that effort could be impacted or some of those initiatives challenged under this same heading?
Well, now that you have the Inflation Reduction Act, I think that's made it pretty clear that Congress is on board with major efforts to get government agencies to speed the transition to green energy. The one specific statutory change there is that they did add an amendment to the Clean Air Act that explicitly defines greenhouse gases as pollutants. So in a way, you've codified the Massachusetts versus EPA decision from 2007, and you wouldn't be able to roll that back now without new legislation from Congress. So I think that Inflation Reduction Act has really substantial implications for environmental law.
I hate to disagree with Bob about anything ever, but I'm actually, I'm more skeptical that the Inflation Reduction Act would influence this court's view of the major questions doctrine as it relates to greenhouse gas emissions and agencies trying to do things on climate, simply because, I think that the way you read the Inflation Reduction Act depends, it's sort of like reading tea leaves. It's sort of how you want to read it. I mean, on the one hand, it authorized a huge amount of spending on the energy transition. And as Bob said, it also made clear the EPA's authority to regulate greenhouse gas emissions generally. On the other hand, you could read it as a much more limited intervention that, again, declined to enact any kind of carbon pricing mechanism like cap and trade or a carbon tax, so that it was not authorizing agencies and certainly not authorizing EPA to go kind of full speed ahead on climate regulation. And, I think from the majority's perspective in West Virginia versus EPA, the problem there wasn't that EPA was regulating carbon emissions, right? The problem was that EPA was regulating the energy sector. At least that's not how I see it, but that's how the majority saw in that case. In terms of environmental justice, this is a really hard one to predict because you have to look at the elephant and you have to look at the mouse hole. So, environmental justice could be seen when agencies try to do things on environmental justice could be seen as a major question in the sense that, the allocation of resources in the energy transition and the reduction of burdens that have fallen on particular communities disproportionately is a really big deal. Depending on how you define what a major question is, this could be a major question. It's also a question that doesn't fall squarely within each agency's mandates from Congress in the way that, say, environmental protection might under NEPA, although NEPA is sort of a way in here, right? The National Environmental Policy Act, because it requires all agencies to make their business considerations about the impact of their actions on the human environment, right? Which is not just implications on their actions on the natural environment, but the human environment, which has been taken to include considerations of environmental justice. So from the mouse hole's perspective as well, there is clear statutory authorization for agencies to consider environmental justice impacts in evaluating their major actions. I think there is a way in there to argue that this is squarely within the mandate of all federal agencies under NEPA. But again, you have to look both at how significant the issue is and what the agency is actually doing to further environmental justice in a specific instance, and also at the statute. My worry about the major questions doctrine is that it very quickly devolves to generalities. And then in fact, if we give the Chief Justice the benefit of the doubt, I think what he was trying to do is look very specifically at what an agency's action is, what it's doing in a particular case, and then what its statutory authority is, and sort of look at that match. That may be too generous, but that's what I'm trying to believe.
Thank you both. Turning to Sackett for the moment, audience question. On Sackett, what do you see as the distinctions between the Sackett's proposed test for when wetlands are covered by the Clean Water Act and the test identified by Justice Scalia in Rapanos? Is it possible the courts would reject the Sackett's proposed test and Justice Kennedy's significant nexus test and simply adopt the Scalia test?
Yeah, that's an interesting question. It's clear that the Sackett's test is even narrower than Justice Scalia's test. So one thing possibly would be to have the court move towards Justice Scalia's test and not go with substantial nexus. One of the things that Justice Jackson was pointing out in oral argument, though, is all the Sackett's arguments seem divorced from the purpose and objectives of the Clean Water Act. That if Congress broadly expressed the purpose as to maintain the physical, chemical, and biological integrity of the nation's waters, then you would want to consider substantial effects. And so I don't think there was any real sympathy for the Sackett's test, because the twist on it that's different from Scalia's test is that it would explicitly say, once you've got a road or a berm between your property and a jurisdictional wetland, you cannot yourself have a jurisdictional wetland. And I don't think anyone seemed to be buying that. So I don't think that they'll, in fact, adopt the Sackett's proposed test.
Jay, can I jump in to answer a question you didn't ask about administrative law?
Absolutely.
Great. So I wanted to talk for just a minute about the future of Chevron deference. This is the idea under Chevron versus NRDC that courts will defer to an agency's reasonable interpretation of an ambiguous statute that it administers. This has been with us since 1984. I mentioned it in the context of West Virginia EPA because the major questions doctrine is one way in which the court has chipped away pretty significantly at the idea of Chevron deference in recent years. The major questions doctrine has been applied at various stages of the Chevron analysis. But as a threshold matter, one could say now the major questions doctrine stops the Chevron analysis from proceeding at all. That if it's a major question as identified by the court, it sure looks like the court's going to resolve the question of how to read the statute itself and not get into Chevron step 1, is the statute ambiguous, not get into Chevron step 2, if ambiguous, is the agency's interpretation reasonable. And this matters hugely for environmental law because the rollback of Chevron does have, I believe, a long-term, at least anti-regulatory bias in the sense that it makes it harder for agencies to enact rules under existing statutes to address contemporary problems. The court has so far declined to overrule Chevron outright. It had a couple opportunities to do that last term in American Hospital Association and in Becerra versus Empire Health, where the agency just ignored, or the court rather just ignored Chevron, just didn't mention it in cases where it could clearly have applied. And this has been a tack the court has assumed more and more frequently. And so the question is, will the court take an opportunity in the future to expressly overrule Chevron, or will it continue this sort of gradual chipping away, resolving, finding more cases to be clear, but not mentioning the Chevron analysis as it did last term, invigorating doctrines like major questions? There's one opportunity in particular I wanted to mention for the court this coming term, which is Buffington versus McDonough. It's a Veterans Affairs claim, and the case squarely presents the question, should Chevron be overruled? It involves a veteran's disability benefits claim where the statute doesn't clearly govern the precise question at issue, and the Federal Circuit has applied Chevron and deferred to the VA's interpretation of that provision. So the question is, will the court take this case? Will they use it as yet another way to chip away at Chevron deference? Will they, for example, apply the canon, the pro-veteran canon of interpretation as part of the analysis, maybe using that as a way not to reach Chevron in the first instance, which limits Chevron's domain even further? Or will they say it's time for Chevron to go? This has been a question on our minds for years and years. Maybe this will be the term where the court actually decides the issue. I don't think so. I mean, my best prediction is that the court will just continue to chip away. We know that Justice Gorsuch and Justice Thomas would like to see Chevron go, but my hunch is that the Chief and maybe even Justice Kavanaugh and Justice Barrett would prefer this gradual shrinking of the domain of Chevron.
Sharon, a follow-up question from the audience on pending cases in that corner. Do you have any information on the 10th Circuit Aposhian decision that addressed the rule of lenity versus Chevron deference in interpreting regulations that have civil and criminal implications?
Yeah, so I believe the court denied cert in Aposhian this morning, and it's in its 48-page order.
Bob, anything to add on the Chevron point, which cuts across a lot of the court's cases and been subject to a lot of speculation?
Yeah, it's been observed regularly that litigants very rarely cite Chevron these days in the Supreme Court because they know a majority of the justices have already expressed hostility to it. So that's not the case in the lower courts, but in Supreme Court, it's almost like, Chevron's the walking dead, and it's just a question of when the court's going to execute it. I did want to just quickly respond to the question. Apparently it wasn't clear about the 404G issue, which kind of dominated much of the oral argument today in Sackett. Here's what happened. The Corps in 1977 adopted regulations that defined adjacent wetlands covered by the Clean Water Act to mean bordering, contiguous, or neighboring. And that then was criticized. It's subject of some congressional hearings. The House passed a bill that would have narrowed Section 404 to a subset of traditional navigable waters and wetlands adjacent to them, but the Senate rejected it. And Congress then what it did in amending Section 404 to add Section 404D specifically stated that the 404 program covered navigable waters, including wetlands adjacent thereto. So it's a great statement that in light of the fact that Congress was aware that this definition existed that didn't require a continuous connection between the two, it approved legislation in the Clean Water Act that's there today, and the Corps' regulations are still there today to suggest that adjacent wetlands don't have to be immediately abutting. And that was the big thrust of the argument this morning.
And I think, Bob, that's such a terrific example of the kind of in the weeds, nitty gritty statutory analysis that frankly, I loved seeing the court do in cases like this. And that's exactly the kind of nitty gritty in the weeds statutory analysis I think is at risk if the major questions doctrine becomes more prevalent and more dominant. We had a question, I think, in the queue here from someone about what's the best textual argument in the West Virginia case for allowing EPA to use generation shifting as the best system of emissions reduction, because instead of doing what you're just describing, or the court sort of working through the implications of various amendments and other provisions and context, right, the court in West Virginia doesn't do much of that and just jumps to the major questions doctrine. So, I think the best textual argument for generation shifting under section 111 is that there's absolutely nothing in the text, structure, history, or purpose of section 111 that precludes it. And if we're all textualists now, as Justice Kagan has suggested, if you look at that word, system, best system of emissions reduction, a system, its ordinary meaning is a kind of a complex unity, right, of parts that are all serving some kind of common purpose. The electricity grid is the prototypical example of such a system. And if that phrase as used in section 111D, I mean, there are lots of limiting factors on what EPA can choose as a system. It has to look at the cost of the system. It has to look at the energy requirements of the system. But nowhere does it say that that system should be more narrowly construed as requiring something at the plant itself. So I think, I wish we'd seen that kind of careful statutory analysis in the West Virginia case.
Yeah, and that's what's so surprising about the decision in light of the previous litigation. When the DC Circuit heard oral argument en banc on the initial challenges to the Clean Power Plan, they heard it for 9 hours, and that was the major focus. The conflict between the two different versions of section 111D and the meaning of best system of emissions reduction. And then suddenly we get to the Supreme Court, and the focus is all on the portion of Justin Walker's dissent saying major questions, because just about all he said at oral argument was major question, major question. And now it seems to be sort of an excuse to avoid having to do the traditional detailed statutory analysis. And at least that seemed to be a major feature of the argument today in Sackett, aside from Alito's comments towards the end.
Got just a few minutes left. One area I wanted to get into, a question for either or both of you, is there's been a lot of speculation, criticism lately about the court's use of its procedures, the so-called shadow docket to take cases and issue orders with substantive impact, if not with substantive opinions. Certainly some of the cases during the pandemic sort of seemed to signal what was going to happen in West Virginia with regard to the major questions doctrine. Bob, I think you pointed out that in some ways the original shadow docket decision in the environmental field was the stay of the Clean Power Plan, Justice Scalia's final vote for the court. What's your take on this trend, and do you foresee increased use of this in our field? Certainly there are cases that would seem to present that. If you think something is an elephant, maybe you better take it up as an emergency question, and so it gets shot more quickly. But do you see that as a trend, or is it too soon to tell?
Well, it all started with the Clean Power Plan litigation, when the court shocked everyone from the very first time, intervening before a lower court had even reached its decision and overturning the lower court's decision to not issue a stay. And what that did was that encouraged litigants. People thought, well, this is a very bold move. The court's not going to like you trying to bother them at this point. And then when the court voted 5-4 to stay the Clean Power Plan, that encouraged other litigants that they could do what had been unthinkable in going to the court and if you look at the original litigation against the Obama Clean Power Plan, the electric power industry and the coal companies, they sued before the rule was even adopted in final form. And the DC Circuit let them hear oral argument on it. And then, of course, dismissed it because it wasn't final agency action. And I think they started realizing if you encourage lawsuits before the rules are even finalized, the courts would be flooded with an avalanche of litigation. But what happened during the Trump administration was that in the previous 16 years of the Obama and Bush administrations, there had only been about 8 emergency motions taken to the Supreme Court. And then during the Trump administration, when they were confident they had a conservative majority that was willing to use the shadow docket to grant them emergency relief, they started bringing so many more challenges, and they won about 2/3 of the challenges. So the incentive is there now to try to get the court, if you've struck a hot button, an issue like religious liberties being infringed, which seems to be on the mind of the court, that you'll be able to get this emergency relief from them. And I think in light of what they did in the Dobbs decision in overruling Roe v. Wade, even though when they granted cert, that wasn't even an issue in the case, as Chief Justice Roberts pointed out in his concurring opinion, criticizing the other 5 for having gone so far to overrule Roe v. Wade. This court has signaled that even things that were thought to be unthinkable or too bold or a violation of norms, they might be receptive to because they're going to act boldly. And that attracts the kind of arguments in these briefs about just overrule Grutter, just overrule Chevron, take a bold step. And in light of the great criticism that the court has gotten as a result of the Dobbs decision, it'll be interesting to see if there are justices from the conservative wing of the court that will join Chief Justice Roberts in trying to avoid bold new earthquakes from the court that are just going to exacerbate the crisis of legitimacy that it faces right now.
Well, we need to wrap up. But Sharon, last word if you'd like it.
I don't think I could end it any better than Bob did. I mean, I don't think that the use of the shadow docket is doing anything for the court's legitimacy. I think the Chief Justice knows it. Another big concern about that shadow docket is, of course, that the court has been starting to rely on those orders as precedent. I mean, Chief Justice Roberts citing some of the shadow docket opinions in the West Virginia case itself. So, with the elaboration of major questions, with this much more aggressive use of the shadow docket and expansive interpretation of an emergency requiring the court's intervention, we have entered a much more activist era of Supreme Court jurisprudence. And I think for the environmental law community, that is not such a good thing.
A little frustrating when justices go around giving speeches saying to understand what we're doing, you just need to read the opinions, and then a lot gets done without opinions being issued. But well, thank you both. That's very, again, we covered a lot of ground, very invigorating discussion. I look forward to seeing the follow-up on a lot of this a year from now. And Madison, anything to add?
Not much, just wanted to again extend a big thank you to all 3 of our amazing speakers today. We so appreciate all of your insights and comments on these cases. And that will conclude 2022's annual Supreme Court Review and Preview. This webinar was recorded, so if you could not watch all of it in the audience, ELI members can find the full recording on the event webpage within a couple of business days from now. Thank you all so much and have a great day.